name is 𝐈𝐛𝐫𝐚𝐡𝐢𝐦. I'm a member of the selection panel, and we welcome you to this interaction session. Asanteni.
Thank you.
So we ask you to introduce yourself, briefly give us your profile, indicate if you have any awards or honors, and if you belong to any professional society, and just give us those milestones that you think are significant for us to know, and given that even Kenyans are listening in, they will be happy to know who you are. Welcome.
Thank you, Chair. My name's Ibrahim Rashid Aden. I am an advocate of the High Court of Kenya. I have been in practice for the past 12 years, an advocate of good standing, a member of the Law Society of Kenya. By way of academic background, I have a Bachelor's of Law degree from the University of Nairobi. I have a Master's in Business Administration, specializing in finance, from the University of Nairobi. I have a Master's of Law from the University of Reading, in the UK, specializing in oil and gas. I am an associate member of the Chartered Institute of Arbitrators, and I believe, by way of my academic background, I have the suitable skills to serve this commission. By way of experience, I have been in private practice for the better part of 12 years. I have been conversant with electoral matters through election petitions. As a service provider for the IEBC, I have participated in several petitions. Notably, I was second chair, assisting counsel in IEBC 2017, the first annulled election. I was being led by lead counsel 𝐀𝐝𝐚𝐧 in 2022 also, where we represented IEBC. I was also present in the Wajir petition that went all the way to the Supreme Court. So, by virtue of that background, I do believe I have sufficient knowledge of electoral matters. By virtue of being in active practice also, I am very much conversant with employment matters, very much conversant with procurement legislations and regulations, and I do believe that this knowledge that I have earned has put me in good stead to serve this commission. Chair, I was also part of an observer mission in 2017, accredited by the Law Society of Kenya, where I was fortunate enough to be an observer in Mandera County, Mandera South constituency to be specific, where I noticed firsthand the challenges that face the commission when it comes to polling day matters, where these challenges have a knock-on effect when it comes to election petitions. So I do believe that based on my experience over time and the knowledge that I have garnered, it has put me in good stead to sit before this panel and put my application across and say, listen guys, I feel like I can serve the commission to the best of my ability. Thank you, Chair.
Thank you very much. I want to ask Linda to ask you the next questions. Linda, please.
Thank you, Chairman. Mr. Adan, what skills and competencies have you acquired outside the legal profession and education that you think will help you in the execution of your mandate as an IEBC commissioner in the event you are taken up?
Thank you, Linda, for your question. When you look at the Act itself, it sets out various disciplines that require somebody to become a member of this commission. In as much as I am a qualified legal profession, I bring on board various skill sets. Number one, when it comes to electoral matters, having been conversant with election petitions, especially from 2017, where the Supreme Court made a determination and annulled the election on the basis of several factors, I do believe that I can make a meaningful contribution to the Commission. When it comes to my management skills, having been an advocate for 12 years, I have been a managing partner in the firm of 𝐸𝐻𝐻𝐸𝐻𝐻, where I have honed the necessary skill set to lead a team of around 8 associates. We have 2 partners, where I have been able to manage the litigation department, manage the commercial department over time, and that has given me a good knowledge and grasp of management skills. My master's in finance also aids me in making financial decisions, prudent financial decisions, where I do believe it will aid the Commission in making sound decisions when it comes to budgeting, expenditure, and financial issues. Also, in another related discipline, having practiced law also, it has given me a good sound foundation when it comes to survey and land matters. And one of the mandates of IEBC is boundary delimitations. And I do believe that having that necessary skill set will also aid me going a long way. I've also assisted youth groups from my community with regards to governance issues, and being a leader from the community, I do believe that it will aid me in making decisions on behalf of the Commission, together with the Commission and other commissioners, when it comes to making sound policy that affects perhaps maybe the youth.
Now, in your career journey, have you find yourself in a situation whereby you have been in a pressure environment, noting that in the recent past, the IEBC election year is usually packed with a lot of pressure, political pressure, and you are required as a commissioner to be able to be tested and tried and come out as a strong individual and contributing as strong factors in the rest of the team. Have you found yourself in such a situation whereby your leadership skills have been tried and tested?
Thank you, Madam, for your question. Honestly speaking, being an advocate is a high-pressure environment, because every other day you represent a client who believes that you are the problem to his solutions. And IEBC is a high-pressure environment. And I do believe the skill sets that I bring on board, being proper communication skills, having people skills that can aid the organization, especially when it comes to the challenges that the Commission face, Chair, when it comes to disputes amongst commissioners, disputes with stakeholders. I do believe proper stakeholder engagement is necessary when it comes to having proper meaningful engagements that will solve and diffuse the tension. Because the way to solve tension is to communicate. Effective communication aids and destabilizes even people who have a hard position and a hard stance. So apart from that, also, I do believe that marrying these two set of skills, whereby you come with knowledge and you come with communication skills, and you're humble enough to cede to grounds that other people have, will aid in solving pressure and sorting out the tensions that exist in the room. Thank you.
Thank you, Mr. Adan. Thank you, Chair.
Thank you very much. I want to invite Caroline to also ask Adan some questions.
Thank you, Chairman. Ms. Adan, welcome again.
Thank you, Madam.
I'll pick it up from where my colleague has left it. I hear you speak about your experiences in electoral matters, and particularly your litigation experience. So perhaps you can take us through your understanding what is the meaning of the burden of proof in electoral matters, in election petitions, as enunciated by the Supreme Court.
The burden of proof in civil matters, because an election petition is a civil matter, is on a balance of probabilities. Unlike criminal matters where the burden of proof is beyond reasonable doubt, the Supreme Court has also put a more stringent, or let me put it as if it has raised the bar from a balance of probabilities, but to a higher level of balance of probabilities.
So applying that burden of proof, how did the Supreme Court in 2017 annul the results? What did it look into when it was annulling the results in 2017?
Thank you very much, Carol. Remember, in the 2017 election, the court moved away from the 2013 position where it said that procedural irregularities does not hinder the substantive position when it comes to IEBC and result declaration. So in 2017, the main issue was that the results were announced without the proper, all the Form 34As being transmitted. So when you look at that, whereby this is a strict position of the law, whereby verification of these Form 34As is necessary. But however, on stricter scrutiny, it was found that some forms did not even have, watermarks and proper seals. Around 11,000 polling stations had not even submitted their Form 34As. And it's on that basis that 2017 was annulled. And looking at it, it is the Supreme Court just looked at the strict position of the law, in that if the law provides for transmission and verification of results, has IEBC undertaken its mandate? So that's the position on which it was annulled.
Okay. Progressively, how did the Supreme Court then depart from that position and use the same standards in not annulling the 2022 results?
Thank you very much. In the 2022 position, the forms, the substance of the forms were the ones which had a problem. The forms had been sent. The issue was that the application for scrutiny and the application for scrutiny of ballot did not yield the desired result by the applicants. And in 2022, again, most of all the Form 34s had been transmitted and tallied. The only challenge now that existed in 2022 was with regards to whether stray ballots should have been indicated on on the Form 34As. And this is a recommendation the Supreme Court later made and said, you amend these forms to that effect.
Okay, so to what extent then did the Supreme Court's decision in 2022 redefine the constitutional standards for electoral integrity, particularly concerning technology, burden of proof, and the threshold of fairness and justice?
Thank you. The 2022 election set out certain legislative gaps. As you have set out, one was with regards to the forms. They said that there is a need for these forms to include a column for stray ballots. They also set out that the form needs to also include other signatures like those of the observers and the agents. With regards to technological integrity, the Supreme Court pushed for more stringent and more, can I say, improvements on technological integrity when it comes to servers. The issue of Fungua server came about in 2022, whereby the Supreme Court set out that for IEBC, there is need for us to have a technological integrity in the transmission model, the voter identification model, or the biometric voter model. So 2022 basically set out some legislative gaps where IEBC now needs to take up, and bearing in mind whatever reforms that were pushed by NADCO to push for these legislative gaps to be addressed.
All right, so just a follow-up. In addressing the technological failures or lack of compliance with technology and the burden of proof in 2022, what is it that the Supreme Court said that would determine if the failure was material? What is it that the Supreme Court is looking into? And should you become successful as a member, what then were the recommendation, or what is the law that guides the IBC when it is carrying out its mandate insofar as any problems or any issues that may arise when using technology in the transmission of results or in any other electoral process?
Pardon, please repeat your question.
I hear you what you're saying, but I am not getting the substance of why the 2022, the Supreme Court did not annul the results, despite the fact that there existed other issues around the electoral system.
In 2022, if I get you correctly, in 2022, the Supreme Court, in determining the results in favor of our current president, looked at the procedural regularity by IEBC when it comes to the voter transmission, when it came to the tallying at the Bomas of Kenya, and the announcement of the results. So they looked at the strict letter of the law and even set out the position that the chairman did not need to consult as set out in the IEBC Act, that he is the one who had the mandate to announce the results. So they set out that the procedural regularities, again, it went back to the procedural regularities as set out in the 2013 election. Thank you.
Okay, thank you. I wish you well. Thank you, Chair.
Thank you.
Thank you. I want to invite Madam Koki to ask you some questions, please.
Thank you very much, Chair. Wakili Aidan, I want to follow up on the same. This is your area of expertise, and therefore I want to bring it now down to the IEBC and refer to Article 88.4, subsection E, which I'm sure you are familiar with. So what we are looking for is not just the role of IEBC in resolving disputes across or around all the phases of the electoral cycle, but what you think would be whether IEBC has sufficient authority to actually resolve the disputes that come throughout, from the registration of voters or delimitation of boundaries all the way to the declaration of the results in an electoral cycle. So each one of these activities, and there are very many, has potential for disputes. Do you think that IEBC has sufficient authority to settle those and address those disputes? And then if you think so, then I will ask you my follow-up question.
Thank you, Ambassador.
You can demonstrate that
Yeah.
authority with the examples. Just pick 2 or 3 of
Number
the
1.
electoral cycle.
Yes. First of all, let me highlight what the election cycle entails so that we can break down from there how IEBC's mandate are. The election cycle, there is the pre-election cycle, there is the election cycle, and there is the post-election cycle. The pre-election cycle is with regards to voter registration, where a party feels like there's a dispute with regards to registration of a voter. He can raise that issue with the registration officer, who is an employee of IEBC, who has mandate to solve it.
Yes, like what kind of a dispute in voter registration can
Voter
arise?
registration, I can give you an example where, say I am registered as a voter in Nairobi. I go to the mobile app, I verify whether I am a voter registered in Mandera, and then I say, listen, these details are not my details, so I can raise the issue with the registration officer, so that at first hand, the registration officer can solve that dispute. From that cycle, there is the nomination cycle, where disputes also arise at nomination stage. At nomination stage, political parties undertake various candidate nominations. So when disputes arise at that stage, the returning officer is the first point of dispute resolution. In the event that he fails, this is elevated to the commission. The commission now sits in a capacity as an appellate jurisdiction to resolve these issues. There is a regulation also that was put out in 2017 in the Wajir determination, where the Supreme Court also held that any pre-election dispute shall be conducted by IEBC pre-election. That's also a dispute resolution mechanism of IEBC. Come to the election stage. At the election stage, IEBC's mandate is greatly reduced because IEBC no longer is an arbiter. It's the court which can handle election petitions. And that's a clarification that's necessary to make, because IEBC now becomes a party to the dispute.
Thank you. With all the mandate that is given to IEBC under Article 88.4, do you think they have sufficient resources, money, to be able to address and resolve disputes?
Of course, you cannot
while you answer that, just say what you would do should you be successful about that particular issue.
Of course, IEBC's dispute resolution mechanism is sufficient. However, we don't also want to overreach, judicial overreach, whereby IEBC is now trading in other people's territory. So I believe IEBC, to reduce the disputes, should act on election preparedness, whereby they train their staff very well, whereby they do logistical planning well, where they put in place security measures at poll day, so that they can now use that to reduce the election disputes. So practical examples is on polling day, and preparedness of presiding officers is what becomes a challenge in most of these election petitions, whereby you find so many questions arise out of IEBC's inadequacies. And this is a tribute to IEBC failing to train their staff adequately. And sometimes when it comes to also nominations, the challenge is also the stakeholder engagement and the civic education that IEBC has not undertaken adequately and sufficiently within the political parties.
Thank you, Wakili, and thank you, Chair. All the best.
Thank you very much, Ambassador.
Okay, I want to ask FCPA. Can we to ask you some questions, FCPA, please?
Thank you, Chair, and Bwana Adan. Pending bills has been a big key topic of discussion in this country. And as at, I think, June last year, there were a total of almost 700 billion in pending bills. And IBC has not been left behind in terms of pending bills. And in their list of pending bills, legal fees is the leading pending bills at IEBC. They have a budget of over almost 3.3 billion, 3.2 billion in terms of legal fees. So noting that you have a legal background, if appointed as a commissioner, you will be offering legal advice to the commission. So what strategies and policies will you put in place to ensure that this issue of pending bills and the huge budget of legal fees is addressed at IEBC? Thank you.
Thank you, FCPA. I think, first of all, for us to be able to reduce the pending bills, we need to form a committee. Similar challenges have been faced even with county governments, whereby there is need for audit of these legal fees on the basis of which ones are verifiable. Sit down, holder, committee, stakeholder, call these advocates to a round table, and then negotiate so that you can see whatever is verifiable can be reduced. Number two, budgeting is also crucial because you cannot be sourcing for services on the basis of funds that you don't even have. So it's crucial because you see IEBC's enormous legal budget arises when it comes to election season, because even lawyers call it the boom season when it comes to election petitions and litigations that follow after. So if you can set out and map, have framework contracts with advocates so that you can negotiate also their fees in advance, bearing in mind that advocates' fees are also regulated by advocates' remuneration order. Another suggestion that I can come up with is having in-house counsels, whereby this can greatly reduce the outsourcing of outside legal work to reduce the cost that is being faced by the Commission in defending litigious matters. Another suggestion will also be basically the first in, first out rule, whereby the first bill that comes in is to be settled first.
Should IEBC actually be in court?
IEBC is an arbiter. You see, advocates will agree with me that when it comes to, I'll give you a practical example. When it comes to land matters, the chief land registrar is always in court. Why? Because he is the custodian of the documents. In this scenario, where two parties go to court together in election petitions, IEBC being the arbiter is mandated to be there so that they can produce the documents. So what needs to be done is proper training for staff, capacity building amongst, of course, the people who conduct the election and the returning officers and county returning officers, so that this documentation can be produced systemically at the end when each and every party cites a dispute. Because, you see, at the end of the day, any person has a right to ventilate his issue. So you cannot say that IEBC cannot be there as an arbiter, as the person who, as the referee, basically, in that election.
I thought there will be a litigant, somebody who goes to court, then there is a defendant. So why should IEBC be there?
They are the custodians of the document. There is remember, Section 86 provides for application for scrutiny of ballot boxes. So if IEBC is not there, who will be producing those documents? You see, a court order only affects a person who is a party to that suit. If I'm not a party to that suit, I will just file it away if I'm served with those documents.
Thank you, and I wish you well. Back to you, Chair.
Thank you very much. I invite 𝐸𝐵C to ask some questions. Evans, please.
Thanks so much. Ibrahim, now, in trying to establish your suitability for the work of the IEBC Commissioner, please tell us your understanding of the roles of the Commissioner and the Secretariat in terms of recruitment and supervision of staff, their distinct roles.
Thank you, Mr. Misati. If you look at, I'll first set out the two roles. The role of the Commission, Mr. Misati, is to oversight the Secretariat and to provide strategic and policy guidelines for the Secretariat. The work of the Secretariat is to implement whatever that strategic plans that have been set out by the Commission. When it comes to recruitment, the Act specifically states that the Commission shall recruit the Chief Executive Officer. From there, the rest of the members of the staff of the Secretariat will be recruited by the directorates within the Secretariat. Remember, the Act also sets out that the Secretariat can put themselves in the position of directorates, agencies, committees. So when it comes to recruitment, the strict latter sense of recruitment shall be done by the Secretariat. However, there can be a HR committee which oversights the recruitment that has been done by whether these people are qualified, whether these people have requisite experience to do this work.
CEO wanted to dismiss her staff, and it comes to your notice that it's unfair dismissal. What would be your intervention as a commissioner?
Thank you, Mr. Misati. You see, at the end of the day, everybody is guided by the law. The Employment Act also still covers the jurisdiction of IEBC. For you to make a determination that this person is unfit for office, what you need to look at, first of all, was notice to show cause issued. From there, was a disciplinary hearing issued. From there, did the set out procedure for the Secretariat to follow. And it is at that point that once the Commission's role in dismissal of an employee is to just monitor whether the Secretariat, first of all, followed the set out procedures of, and at the end of the day, the person who signs the dismissal letter shall still be the Secretariat. The CEO of the Secretariat is the person who signs the dismissal.
Thanks so much. The last one, as a follow-up on issues of personnel. During a general election, there is a possibility of having recruitment of temporary staff. Just mention one or two things that is a risk when you are hiring such a huge number of staff during the general election.
Number one, the problem that has been encountered, especially in my experience when I was an observer, was that most election staff are not properly trained. Because of the rush to recruit these people, most of them are not properly trained. So the lack of training brings about small challenges which end up nullifying even ballots. A sanctity of a ballot is not guaranteed because maybe a polling clerk failed to stamp on the ballot paper. Number two, material, there is also a risk, there is always a risk of employees failing to turn up. So you find a polling center is understaffed because there was a rush in recruitment. People just indicated their names as polling clerks and then they failed to turn up. Another risk is that there is a challenge whereby the confidentiality of documents, especially when it regards to polling documents and materials, risk falling in the hands of staff who have not even signed confidentiality agreements and such.
Thanks so much, and I wish you well. All the best.
Thank you.
Yeah.
Okay, Fatuma Saman, would you like to ask some questions, please?
Thank you, Chairman. Mr. Ibrahim,
Thank you.
please tell the panel what are the practical ways, in some of the practical ways, that the IEBC can actually engage political parties to work well and, you know, to reach the goal that they share.
I will first of all start off with Article 10 of the Constitution, which pushes for public participation in anything that a state agency does. This will greatly aid in ensuring that activities of the Commission, when it comes to political parties, are greatly enhanced. Number two, the Political Parties Liaison Committee also provides a critical role in the relationship between IEBC and political players, in that it is a forum where parties sit directly with IEBC and can set out their issues. Another form of engagement will be capacity building, whereby IEBC can train political parties on election laws and regulations and help them understand whatever that is required for them, especially when it comes to the nomination processes. Another form of engagement between IEBC and political parties is when it comes to overseeing the nomination process. Because IEBC, remember, sit in a capacity where they can determine as an arbiter between political players themselves at the nomination process. Another manner in which political parties also interact with IEBC, Madam Saman, is at the appellate stage again. So if IEBC can I call it ease of access of justice, whereby political players, when they feel like they have been aggrieved from the procedures and the process of the nomination process, can also interact with IEBC. Training also political players can also greatly aid in the engagement between IEBC and political parties. I think that's some of the.
Do you see opening for consultation?
Yes.
Feedback?
Yes.
How would they practically do this?
How do you practically do this? You have multi-stakeholder forums. You have barazas with political parties. You have workshops where you can engage them, sit down with them, tell them that this is the agenda for this week. We are coming to Naivasha maybe to discuss these legislative reforms and those kind of policies that need to be introduced. So the forums, there are several other forums that you can engage, maybe through the media, sharing of contacts with, of course, in a structured manner, where you can always document whatever you are sharing with political parties and whatever kind of engagements you are having with them. So a multi-stakeholder forum is very key. Workshops and benchmarking forums are very key for your form of engagement with political parties.
Thank you very much, and I wish you well.
Thank you. Thank you, madam.
Thank you. I would like to invite Nicodemus Bore to ask some questions. Please,
thank you.
Nicodemus.
Thank you, Chairman. Eden,
Yes, sir.
you have served at the bar for
12 years now.
12 years. So you have not worked anywhere else apart from practicing.
I'm sure if there's an advocate over here, she will tell you that practice itself is enough experience, because law is a multidiscipline kind of
No,
profession.
I'm not disputing that bit.
Thank you very much.
I'm just asking whether you have served elsewhere apart from serving in the bar or practicing.
No. In my professional career, I can say apart from private companies where I sit as a board member,
Yeah.
I have not served. You know, service is full-time employment.
Yeah.
But I will not categorize my service as a board member as service itself.
Okay. And in your CV, you've noted that you have indicated that you are good at electoral laws and systems. Now, you are aware about the first past the post system of electoral, and what recommendations will you propose to make our election system more effective? And what do you think about the first past the post election system?
If I get you right, our election system, where, of course, the first past the post system has its own challenges. The first past the post system means it's the winner takes all system, whereby the candidates on the ballot paper, the person who has the simple majority wins. And this in itself disenfranchises the rest of the candidates or who they represent. But to bring it into perspective, in as much as our country has tried to achieve the 2/3 gender rule, because the first past the post system, you can say, leaves out a marginalized section of our society from having able representation. How do you cure that, is the question. And I think our hybrid system of the Constitution has tried to cure that. The 47 county women representatives, remember, were brought in place to cure the obvious delimitations from the first past the post system when it comes to gender representation in parliament. When you look at the county assemblies also forum, we have tried to incorporate the progressive approach whereby we have gender top-up lists when it comes to county representation, and we have seats for minorities. This is the hybrid system that we have tried to incorporate so as to cure the first past the post system. Thank you.
Thank you, Adam, and all the best.
Okay, I invite Professor Adams to ask you some questions.
Just to follow up, Adam, on what my colleague Bora has asked you. So this hybrid system, what is it called? We talked of first past the post. What is this hybrid called?
Progressive party approach. It's being practiced in Germany, I know, whereby party lists are submitted, and then the party submits its list of candidates, and then you choose the party, and then the candidate goes through on that system.
And what is it called? The reason why I'm asking that is that there are stakeholders in Kenya who are of the view that to cure the anomalies of Kenya's electoral process, we need an alternative electoral system from first past the post. What are those alternative systems?
Progressive parliamentary approach?
Okay. what is the difference between leadership and management? Because you have been a managing partner. You have been a chairman of, I believe, the Kenya Forex and remittances. So there's a manager and there's a leader. Is there any difference?
To some extent, anybody can manage, but very few can lead. So that is I can say the distinction in the first place. However, what I would like to put into perspective is that leadership comes with some form of integrity. Leadership comes with ethics. Leadership comes with a more clearer role whereby people tend to follow leaders. Managers give directions. Leaders lead from the front, basically.
Thank you. Describe Ibrahim Rashid Adan's leadership style and how this would impact on the commission if you are made a member of the IEBC.
My leadership style, a people-centric approach, whereby you engage people at their level, you have time to hear each and every party's position, transparency in decision-making, and integrity, basically giving people the comfort that anything that is brought about to you will get a free, fair, and honest decision-making from Ibrahim.
Thank you, Chair.
Thank you, Prof. And then if I may ask, how will you handle conflict of interest should you succeed in this process, given that IBC has been your client?
Number one, the first cure, Chair, of conflict of interest is disclosure. If there is disclosure that I am IBC's client, I, first of all, will move away from the firm. I will resign from the firm because the firm, the IEBC in itself is a full-time commission. And when it comes to decision-making that affects anything that brings about conflict in my stint at IEBC, I'll publicly declare that I have an interest over here, and this is my interest, and I disclose that interest. Say to a committee, say to the full commission, publicly, and say that this. Number two is recusal. Because the moment you remove yourself from the decision-making, it becomes clearer that any decision that is made without your input. I believe, and also basically communicating and engaging members and telling them that, listen, now that we are at IEBC and I have no longer any tenable interests in private practice. Thank you, Chair.
How you resign as a managing partner, but what about your proprietary interests?
I will leave it at the door the moment I enter IEBC. Yeah, because you see, at the end of the day, even if it means removing my firm from IEBC, so be it. Because you see, at the end of the day, IEBC is one client out of many.
Okay. Thank you. Prof, do you have some last two questions?
Yes, Chair. Banadan.
Yes, sir.
You have been the chairman of the Kenya Forex and Remittances Association since 2013?
Not 2013. The association has existed since 2013. I was just elected last year, December 2024.
But you have also worked as a principal officer at Pacific Forex Bureau between 2008 and 2012?
Yes,
So you are very familiar with the Forex Bureau in Kenya?
operations, yes. That was my hustle, let's say, when I was in campus.
When were Forex bureaus first established, approved, and licensed in Kenya?
Okay, it was deregulated in 2003.
No,
But
I want when it was first established, approved, and licensed before the deregulation.
well,
But
should
I
I
can
say
always pass.
Yeah, because, okay, 93, I think, after the multi-party election, when we came up with the SAP's structural adjustment programs at Treasury.
Okay. Which two countries of Africa were involved in a historic peace agreement that was signed in 2018 to end 2 decades of conflict?
Ethiopia and Eritrea?
Thank you, Chair.
Thank you very much, Mr. Allen. It's been a pleasure talking to you and listening to you. Do you have any question or comment to make, please, kindly?
Maybe a comment, Chair. I want to assure this panel that if given the position of Commissioner, I would bring meaningful change to IEBC. I do believe that with the skill sets that I have, being a relatively youthful person, the challenges that are being faced by IEBC will...
What do you mean relatively youthful person? Youthful at heart? Or
Don't let the gray hair confuse you, Chair. Basically, under the youth access to government procurement, it says 35 years is where the youthful barrier ends. So at 36, I still feel like I'm relatively youthful. So with that, I think there's a need to bridge the gap between the youth and IEBC, especially when it comes to voter education, when it comes to voter registration. Coming from a marginalized community also, when it comes to training of IEBC staff and staffing issues, I believe that these are issues that at policy level, of course, I can have a great input with the Commission. Thank you very much.
Okay, thank you. It's been a great pleasure having you. Please remember to pick your certificates. The pen and notebook are yours. If you so wish also, you can take the water, and wish you well.
Thank you, members of the panel.
The next candidate, please.